Unacademy. Let's crack it.
Okay.
Yes,
So,
sir.
Kritika, let's say a person is arrested and the person is presented to you after 3 days. You are a judicial magistrate and a person has been arrested. He is presented to you after 3 days. So, in that period of time, in those 3 days period of time, around 1.5 day, 2 days were just required to take or convey that person to your court. Matlab, it was the time required for journey. Will this entire time period of 3 days be included or excluded from the time span of 15 days that you have provided for police remand?
Sir, the time period that is required to the time period of the travel, that will be excluded from the time of 15 days. The day when the accused is presented before the magistrate, from that day, the time period of 15 days is counted.
Okay, okay. Let's say a person has been already sent to judicial custody by you. You have already given a judicial remand to a particular person. Can that person be again put to police remand if need be? Can that person be again put to police remand or not?
Sir, the period of 15 days needs to be taken care of. If it has been more than 15 days that the police remand has already been granted of 15 days, then thereafter such person cannot be given back to the police, like he cannot be granted police remand.
Okay,
And if after 2 or 3 days I have granted the judicial remand to that, if I have given the judicial remand, and if a request has been made from the police that further investigation is needs to be done on their part, then yes, he can be sent to police remand
are
back.
you sure about that?
Yes, sir.
Okay, okay,
Fif-
fair enough. Okay. So when we talk about arrest of a person, what are the other modes of compelling appearance of a person in the court? अगर आप एक मजिस्ट्रेट हैं और आप चाहती हैं कि किसी व्यक्ति को आपके सामने प्रस्तुत किया जाए, तो अरेस्ट के अलावा और क्या तरीके हैं उस व्यक्ति को आपके सामने प्रस्तुत किए जाने के?
सर, फर्स्टली सर, समन्स इशू करके उनको प्रस्तुत किया जा सकता है. अगर समन्स से काम नहीं हो पा रहा है, तो देन वारंट कैन बी इशूड. आफ्टर दैट, अगर डिस्पाइट ऑफ इशूइंग अ वारंट दैट पर्सन कैन नॉट बी प्रोक्योर्ड बिफोर द कोर्ट, देन proclamation is another method by which that the attendance of that person can be ensured before the court. Proclamation is provided under section, as per the provisions of section 82 of CRPC. Uh, a proclamation can be issued for that person to be brought before the court.
Okay. And attachment can go contemporary to proclamation?
Yes, sir.
Okay.
The provision itself provides that there can be simultaneous attachment. Attachment can be done simultaneously with the proclamation
Okay.
to appear, for the person to appear before the court.
Okay. 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 Let's say a person has been presented before the court and the charge sheet is also presented before the court. आपके सामने चार्ज शीट भी आ गई है, आपके सामने पुलिस ऑफिसर भी आ गया है, आपके सामने अरेस्टेड पर्सन को भी ला दिया गया है, विक्टिम भी है वहीं पे. अब अगली प्रोसीडिंग क्या होती है? इसके बाद क्या होगा? What will be the next stage?
Sir, once the charge sheet is presented, the magistrate looks into the case like prima facie. If the magistrate finds that certain charges as framed by the police are uh, if there is a reason believe, or there are reasonable if there are reasonable grounds to believe that the accused has committed the offences as charged, then the court will proceed with the trial. Or if not, then there is also a provision then where the accused can be discharged. if it
Which
is a
provision,
warrant
which provision talks about the same?
Sir, if it is a warrant trial, as charge sheet is presented, so warrant trial instituted on police report. So 230, sir, I'm not able to recall the exact section, but after the charges are, after the charge sheet is presented, then there is also there also lies there a discretion with the magistrate that if he finds that no offense is committed, if he finds that the offense has not been committed by the person, then there is a provision of discharge. 227 of CRPC.
Okay. It's a warrant trial you are talking about, and you are saying it is 227. Are you sure about this?
Yes, sir.
Okay. What is the difference between withdrawal and discharge? Yeah. What is the difference between acquittal and discharge?
Acquittal essentially means we are absolving that person from all the charges, and discharge means if there is need, that person can again be called before the court. So acquittal absolves the person from all the accusations and all the charges.
Okay. Okay. What effect does a compounding of offense do on a particular case? Compounding of offenses का effect क्या होता है? Discharge होता है, acquittal होता है?
Acquittal.
Are you sure? Where is it provided?
Section 320 of CRPC.
Unacademy. Let's crack it.